Good morning, everyone. People in the room and people online. The micro, can you hear me? Yeah, should be fine. Yeah. No, I unmuted the microphone. Can you hear me? Can you see the screen, which I am sharing? And can you see me on the video?
Yes.
Great. Thank you. So welcome everyone to the second EU Pop Summer School. We are very happy about this in a very adapted format. So some of us are here on campus, particularly the speakers, as well as members of the EU Pop team. And some speakers are online and most participants are online. So we welcome you from all around the world. And we hope you will enjoy these 2 days as much as we will enjoy it and as much as we have enjoyed preparing it. So you can see that I have shared my screen and I have actually shared with you the website of EUPOP, and I wanted to basically go through a number of resources we have there for researchers, students, academics, and the wider public to be able to understand what we are dealing with. So EUPOP stands for European Law and Governance in Populist Times. It is a Jean Monnet module, which is funded by the European Commission under the Erasmus Plus program, the previous one, the 2014-2020 program. It runs up to 2022, so next year will be the third and final summer school. In the meantime, we do a series of activities, of course, around the various manifestations of populism, including its extremist manifestations online also, the role of the various branches of powers. We looked at that last year as well, and key concepts of the rule of law and democracy particularly. So we are a team of primarily three people. So you have now met me. My name is Stephanie. And in the room with me is Andrea as well. She's here. And thank you, Andrea, for all your help. And Andreas, who is here as well. Thank you, Andreas, for organizing the summer school. You will have the pleasure to listen to Andreas tomorrow. In addition to us, let's say the full-time members, we have a few special guests. Natalie, who used to be a colleague here, and the inspiration of the module, is one of our guests, but she's not with us today. She was with us last year, the previous summer school. Oulad was also with us last year and published the inaugural Jean Monnet EUPOP guest lecture in the journal, which I will turn to in a second. And last but not least, we had Andreas Ketzis this academic year, a couple of months ago. We had a very interesting session on the role of the European Parliament in times of populism. And last but not least, Professor Korshunov Dmitry, our friend, who is now actually at the CEU. So we need to update his bio, who will be with us next academic year. Plus a number of other guests, such as the one we will have at this summer school and that we will introduce in turn. You have their profile in the booklet, which Andreas has shared with you. All right, yes. And I think it's also on the MS Teams. Okay, great. So let's have a look at the activities before I turn to the summer school. So we do a number of activities, quite a lot of activities basically, and these activities are usually around raising awareness of human rights in populist times and human rights in emergency crisis situations to the young people. And creating resources for researchers. So we have a series of webinars which you can find in the media section of the website. We run LLM modules that are open to anyone For example, you see here the first edition. We run an LLM module on EU law, EU constitutional law and governance in populist times that you're welcome to join. Probably it will run in semester 1 again in the next academic year, 21-22. We run roundtables with guest experts, such as this year we had the opportunity and the pleasure to host the director of Judiciary, where Natalie is currently located, talking about hate speech and freedom of expression. We run, again, a series of guest lectures, as I mentioned before, and we post everything on the website freely. All videos are available openly on the YouTube channel of the university. And we try to publish as many materials as possible, including in the journal. So let me go to the journal, since we mentioned it. The journal is called the Interdisciplinary Journal for Populism. It has a separate website, which you're very welcome to visit. Here it is. It is an online journal. Free accessible online journal. It is indexed to High Online, and you can find the latest call for papers out there. Let me try to close that thing. Okay. You can find the latest call for papers. You can find the different sorts of essays and contributions we welcome with the guidelines, and you can find the members of the editorial board if you are interested. Again, it's us, myself, Andrea, and Andreas, and we have a number of high-profile members of the editorial board who have been kind enough to give us some of their time to support this initiative. So please subscribe to the journal, subscribe to UPOP, and you will be kept informed of activities, and do look at the inaugural issue of the journal, which you can find here under issues, issue number 1, which was published as a result partly of the first summer school last year. And of course, it's very interdisciplinary, but it's also very international. So we have colleagues from Russia, for example, in this issue, and we have colleagues from many European countries as well. Now, let me draw your attention to the prologue written by retired Justice Alkes Haji-Hambis, which is of general application and much breadth, and I would encourage everyone to read it as an introduction to also this year's summer school. It is part of the reading that we have assigned, and you can find the bio of Judge Haji-Hambis in the booklet that we have assigned. The other piece of materials that we actually made available to you, which this one is brand new, is a video recorded by Dr. Nasser Haji Georgiou for the purposes of the summer school. You can find it in the MS Teams folder, and after the summer school, we will actually upload it onto the website. Nassia discusses in that video in very clear and very helpful manner the role of judges in peace-building processes, which is, of course, something that is extremely important when you talk about frozen conflict, but also troubled times. So let me take you to the latest news, and you can see on the latest news whenever we publish press releases or summaries of activities, we place them here. You can see here, for example. Under media, you will find multiple newspapers and other exposures, as well as podcasts, which you're welcome to watch in your own time. Under the summer school tab, you can find the actual content of the summer school last year. So you can find all the recorded webinars as well as a report on the summer school if you click on the press release here. So you're very welcome to enjoy all this and watch all this. Finally, one more resource that is of help and of much use to everyone is the bibliography, which is most of it is open access. If you use limited access, it's actually mentioned there. So Andrea was responsible for this, and basically we tried to outline the most meaningful literature on populism across the world. There will be a second edition of the bibliography very soon, but please, do have a look at it. It's extensive work and very good work. Okay, so this is what I wanted to say about the resources, the journal, and the EUPOP website. Now, let me say a few words about why we have chosen the topic of the judiciary. Why we have chosen the topic of, the role of the judiciary and the role of the judges in populist times. It actually derives from the findings of the first summer school that we had in September 2020, whereby after 2 days of deliberations, of listening to great speakers and engaging in brainstorming, we felt that we had to focus on the judiciary specifically, whereas last year we focused on marginal concepts that were relevant to populism. And one of the reasons why we did this is because we can all witness and testify to the extensive executive dominance happening at the European Union, having an impact on the judiciary and having an impact on judicial independence. The principles of judicial independence are at the heart of the rule of law and democracy, and they are at the heart of the fighting or tackling manifestations of populism throughout the world. So this is the reason why we have decided to basically focus on judicial independence. In the booklet, which you have online, and I believe in Microsoft Teams as well, you have the full program of the summer school for today and tomorrow. So we start with a lecture, which I will deliver, and then we have a short break, and then we have a workshop by our colleague Dr. Klearchos Kyriakidis, who is currently not in Cyprus, so will be online. We will have a working lunch, so for people who are here, those online will have to have a break. And then we will have a workshop by our colleague, Professor Danuta Rudnicka. Did I pronounce it well or not? Rudnicka. Yeah? Rudnicka. Okay. That's okay. Welcome, Danuta. Danuta came all the way from Poland to be with us, so we appreciate it. Tomorrow, we will have another very important and great day with a workshop on the Netherlands and the Dutch courts by Dr. Manders. And then a workshop by Dr. Laulhe on the concept of the development of democracy in the courts, and a closing workshop with Danuta and Andreas. So I think we are very happy and honored to be here and to be able to listen to all of us. Now, let me unshare my screen and share something else. Okay, so is it possible to enlarge the PDF? You think? And remove that thing that we have on the side.
You can remove it by taking the arrow to the left.
Yeah, there's yeah, this one. Okay. Is that any better? I suppose not really. It's not any better because I think we'll have to stay like this. Okay? Okay. I suppose that everybody can see. Yeah? Okay, great. So this introductory lecture is about a piece of work, piece of research and some publications that I did together with a PhD student at the University of Cambridge, Jacqueline Veraldi, who was supposed to deliver the workshop, but unfortunately Jacqueline is unwell. So we wish her well, first of all. And secondly, I have to disclose that I am only the second author. She's the main author of this piece. So I will attempt to explain within 1 hour the main arguments of the piece. This piece is actually going to be published as the inaugural working paper in the EU POP Working Papers series. So there will be a new tab in the resources I have actually shown you just before, so that we will actually create working paper series. A general call to everyone who is interested, including students who is interested to get engaged with the working paper, to get in touch with myself in the first place, so that we can discuss whether your project is suitable for a working paper. So the idea is to actually look at whether judicial independence is an EU concept. And if it is a new concept, what is it made of? Danuta, sorry, it's very difficult for me to speak. Okay, so in other words, if it is an EU concept, then if it has a substance. So the idea is to talk about the substantive requirements of judicial independence in the EU, lessons from times of crisis. The reason why there is a focus on crisis is because throughout my work in the past 10, 15 years, I have noticed that different crises, different phenomena, emergency phenomena have given rise to EU concepts, or if not to EU concepts, at least have given flesh and bone to those EU concepts. So the idea is to look at what crisis situations can teach us in terms of judicial independence at the EU level. But first of all, let's have a look at what is judicial independence, so abbreviated as JI, judicial independence of the EU judiciary, and recent evolution, because judicial independence is not a new concept as such. However, the recent evolution of this concept at the EU level is something notable and something that is worth examining and discussing. If you look at probably the most famous case of the ECJ around the topic of judicial independence that actually arises from the financial crisis, the case of the Portuguese judges, that's how we call it, because my Portuguese is not good enough, but it's Associação Sindical dos Juízes Portugueses, basically, abbreviated as ASJP in the paper and in the slides. Look at this quote, which is actually taken from paragraph 37 of the judgment. Every member state must ensure that the bodies which, as courts or tribunals, within the meaning of EU law, come within its judicial system in the fields covered by that law, meet the requirements of effective judicial protection. Effective judicial protection came to the fore again because of the financial crisis in the years 2010 onwards. Again, it's not a new concept. Effective judicial protection was embedded into the case law of the ECJ from early on, from around the 80s onwards. However, the Treaty of Lisbon and the newly drafted Article 19 of the EU Treaty formalized this principle of effective judicial protection together with the Charter, the EU Charter, Article 47 of the EU Charter. So we saw a renewed interest for effective judicial protection, which a formalization of that principle, which becomes probably the most central principle of EU law at the moment. And from that principle of effective judicial protection, which is formally expressed in the treaties, we now have a body, an impressive body of case law around judicial independence of the EU judiciary. So some of you will wonder what the EU judiciary is. Well, actually, the EU judiciary is everything. It's all the courts of the EU. It's not only the EU courts, it's also the national courts, because the national courts are the main actors of the application of EU law. That was again confirmed lately in one of the opinions of advocate generals in the Polish cases. We have a lot of Polish cases, and Danuta, I'm sure, will talk about that. But in this one, so Advocate General Bobek, on the 20th of May 2021, actually talks about EU judicial space. And look at this quote. It is vital for the European judicial system categorically to insist on minimal guarantees of judicial independence and impartiality for all its constituent members, so all the member states, irrespective of whether in the individual case before a given court, EU law is in fact being applied. So we move away from the restrictions of the EU Charter, which requires that judges should apply EU law in order to apply the Charter. That's not new. But what is powerful in this quote is the way he refers to all the constituent parts or members of the EU judiciary. So it's all the courts, and not only all the courts, the tribunals, and probably all the bodies that have some sort of judicial appointment or authority. So we are in a decentralized system, and this is something that we should remember. So this quote is from the opinion in the Procuratura case, which is currently pending before the ECJ. Right, so what are the implications on the member states and their courts? By the way, I have put pictures in the slides. All the pictures are freely accessible. I forgot to mention that. So we already know that Article 19, paragraph 1 of the EU Treaty, second subparagraph, has been developed in the case of the court, and as President Lennart puts it very elegantly, the court has clearly established a general obligation for member states to guarantee and respect the independence of the national courts and tribunals via the interpretation of that article. We also witnessed for the first time a member state found to have failed to fulfill its treaty obligations by violating the principle of judicial independence. I quote here our colleague Laurent Pech from the Reconnect Horizon 2020 excellent project on the rule of law. When the Commission brought proceedings against Poland via Article 258 of the TFEU on the basis of a violation of Article 19, paragraph 1, second subparagraph. So this is something extremely important and something which those of us who were looking at Article 19, paragraph 1 from the time of the Lisbon Treaty from 2009 were actually discussing and debating about what is the value, what is the role. Here it's been used. It's actually been used as one of the main milestone provisions of the treaties. And again, and again, and again. So Danuta will probably cover those cases as well. I mean, the two cases that I mentioned here, Commission versus Poland, abbreviated as the Independence of the Supreme Court, or ISC, and the Commission versus Poland, the Judges' Retirement Age cases, abbreviated as JRA in the paper. So since then, we have seen a proliferation of cases on this basis, on the basis of Article 19, paragraph 1, in multiple or from multiple member states. I'm trying to figure. Even Cyprus has case law on Article 19, paragraph 1, but not in this context, in a different context. Okay, so what's so special about it that we have to spend 1 hour discussing it? Well, it is special because it's not just about whether a court or a tribunal now has the jurisdiction to actually refer a matter to the ECJ under Article 267 of the TFEU, which was largely what was happening in the first part of the development of the principle of judicial independence, and was to assess whether that is indeed a court or tribunal in the eyes of EU law. So it was a matter of admissibility, in other words. This is not the case anymore. In the past 10 years, 15 years, we have now seen case law based on Article 19, paragraph 1, whereby we're looking at an infringement of substantive rules of EU law. So the question is, what are the substantive rules of EU law that can be breached? Well, we do have an indication if we look at the case law of under Article 47 of the EU Charter, but actually the case law under Article 47 of the EU Charter is somehow limited. It is limited because that article can only be used to the extent that the national judges are actually applying EU law or looking at EU law. So that means that, for example, in the context of the financial crisis, many of the cases brought before the ECJ fell short of a violation of fundamental rights of the depositors, for example, because arguably the court found that there was no application of EU law in the European Stability Mechanism, for example. So there is a very famous article, a very famous paragraph in the Pringle judgment, for example, which specifically states Article 47 of the EU Charter is not applicable. We have moved on since then. I remember, back then, time of Pringle, no one had paid attention to that section of the judgment, which was the last section of the judgment. It was just a couple of paragraphs, and no expert had paid attention to it. Until, this kept coming back, and Article 19, paragraph 1 made its way. So the advantage of Article 19 of the EU Treaty, from the perspective of invoking a requirement of judicial independence, is that this provision does not have to meet the Charter's scope hurdle that we just described now. Under Article 19, the aims to guarantee effective judicial protection in the fields covered by Union law, irrespective of whether the member states are implementing Union law within the meaning of Article 51, paragraph 1 of the EU Charter, is a standard formula which you're going to find in the case law of the court. And you have some examples here. Also, Article 19 is composed of two paragraphs. Paragraph 1, subparagraph 2 that we are focusing on here, but there's also paragraph 2, Article 19, paragraph 2, with a third subparagraph that actually looks specifically at obligations of members of the EU court. So it basically requires both arms of the EU judiciary to be independent, the national arms and the European or the EU arms. So let's have a look then at the substantive requirements of judicial independence in the EU. Do they exist? And if they do exist, what are they? Because they are not written down in the treaty, in fact. So, first of all, it's a mixture of the case law around Article 19, paragraph 1 of the EU Treaty, around Article 47 of the Charter, and Article 267 of the TFEU, which triggers most of those cases. So, we, with Jacqueline, we basically sort of created a test, if you want, or a benchmark, which we think can be applied to try to identify those substantive requirements of judicial independence in the case law of the court. So, and it is based, of course, on the formulation of the court itself. You have the formulation here. So we are looking at whether a specific measure under scrutiny is such as to dispel any reasonable doubts in the minds of individuals as to the imperviousness of that body to external factors and its neutrality with respect to the interests before it. So actually, that is a formulation that we find in many cases. Before the Court of Justice of the European Union, you have a long list of cases where that formula is embedded. And actually, it is the same formulation, or it is drawn from Article 6, Paragraph 1 of the Convention of the ECHR, basically. So that has now become a standard against which measures taken in respect of the judiciary have been scrutinized at the EU level. So, as I said, we have been trying in the paper to, first of all, identify that benchmark or that standard or that test, and then apply or use that test. So, the question that we ask is, how can one determine whether a given measure is liable to give rise to reasonable doubts in that respect? Our argument is that the substantive requirements of judicial independence can be found in an analysis of the essential guarantees and fundamental rules of judicial independence, which are articulated in the court's case law. So I will explain what is one and what is the other. So our rationale is that we will try to demonstrate in this paper and in the presentation here that the court has found that for a body to be considered independent, certain essential guarantees of judicial independence must be provided, and that certain fundamental rules integral to the establishment of functioning of the judiciary must be respected. So our tools are these two variations of judicial independence: the essential guarantees, the guarantees that the ECJ has deemed essential to the safeguard of judicial independence, and the fundamental rules forming an integral part of the establishment and functioning of the judicial system. This is taken from a recent case, the case of Simpson and AG, which I will develop in the second part of the paper. So, in a nutshell, what are those essential guarantees and what are those fundamental rules? Essential guarantees that can be found in the case law of the court, and not only in the case of the court, that are recurrent in the literature, whether at the national level or the European level, include, this is not an exhaustive list, right, include the provision of appropriate disciplinary regimes, commensurate remuneration of judges, safeguards against executive discretion resulting in undue external intervention, pressure, and the judiciary. And of course, when we think about those guarantees, we have examples in mind already, and across the globe, one would say. And we start painting the picture of the link with populism as well. The fundamental rules, they are the more elevated level, if you want. They are the ones that are necessary for the forming of a judicially independent system. So, as I said, in the case of Simpson and AG, the court used this formula to determine when a breach of an existing rule related to the supranational EU judiciary also entails a breach of independence, by distinguishing between fundamental and non-fundamental rules related to judicial appointments and term durations, additional rules related to other types of measures, such as remuneration or disciplinary regimes, which can also be considered integral to the establishment and functioning of the judiciary. So some rules are elevated to fundamental rules. I hope I haven't lost you so far. Yeah? Any questions online? No? Okay, we'll continue. So, the crisis context is extremely helpful to try to tease out those guarantees and fundamental rules. Why? Well, because the crisis context, whether you take the rule of law crisis in affecting quite a few member states, but not only, affecting also countries outside the European Union, or Brexit, or the financial crisis, the sovereign debt crisis, which I have already spoken about, which, by the way, is unfortunately not the only example of economic austerity we have. We are going to have a second one quite soon, which is COVID. The COVID pandemic, or the economic measures resulting from the COVID pandemic. All of those exacerbate the deterioration of the rule of law, and all of those, unfortunately, are feeders of populist trends, which are the results of, or let's say, the manifestations of those turbulences or emergency situations. So they feed into each other. And we can see manifestations of this on a daily basis everywhere. So through the crisis focus, it is possible to basically look at an EU judiciary. When we say EU judiciary, we mean all the arms, to be made more resilient to crisis and more sustainable. Because if there is one point in time where we need sustainability of rights, it's crisis time. So the idea here in this paper is to try to enhance the independence of the EU judiciary through a number of methods and tools. Okay, let's try to distinguish between essential guarantees and fundamental rules. I hope that you will find the distinction clear, but feedback is welcome. So we suggest a few steps. Step number 1. Where a case concerns the introduction or application of a measure affecting the judiciary somewhere in the European Union, under Article 19 of the TEU, the question should be whether the given measure in question fails to provide the essential guarantees of judicial independence required in that context. That is the first question, which we are going to answer now and give indicators. The second step is a more serious step, or more elevated step, where the case concerns a breach of a rule of law or rule related to the judiciary. And this rule does not in itself fail to provide an essential guarantee of judicial independence, but nevertheless is affecting the rule of law. It can be asked whether that breach concerned a fundamental rule integral to the judiciary's establishment and functioning, so at the core of the judiciary. If the answer is yes to either of these two steps, questions, independence of the relevant judge or court required by Article 19 of the EU Treaty is likely to have been infringed, and vice versa. So let's have a look at step 1 and the essential guarantees, and I will try to guide you through the enormous body of case law available at the EU Treaty, at the EU Court. Of course, it would be very nice to do a comparative exercise with the Strasbourg Court, which we have not done in this paper. We have done it elsewhere, but not in this paper. So the first essential guarantee which seems to arise or transpire from the case law of the court is the need for appropriate structuring of the disciplinary regime, including removals from office of judges. So otherwise, this can of course be used as a political tool, as it is currently being used. So to ensure this essential guarantee, several safeguards have been identified in the case law of the court. And they make perfect sense. They are not new. They are based on existing principles of judicial independence in different international bodies. So first of all, there's a focus on rules to define the conduct amounting to disciplinary offenses, and the penalties actually applicable must be clear. Then another guarantee is to provide for the involvement of an independent body in accordance with a procedure that fully safeguards the rights enshrined in the Charter. Again, that comes from case law of the court. And together, these requirements were deemed by the CJ, these two requirements, to constitute a set of guarantees that are essential for safeguarding the independence of the judiciary. Again, that's contained in two of the Polish cases. This is very important because it actually is the backbone of the next essential guarantee, which is irremovability. In other words, the fact that judges can only be removed subject to very, very specific and restrictive conditions. So, irremovability. We go to the Polish rule of law crisis. Okay, irremovability is not something new before the court, whether it's the Strasbourg court or the Luxembourg court. We have seen questions of irremovability arising in the context of effective judicial protection, in the context of the European arrest warrant, the context of the Charter, and now the context of Article 19. But there is a crucial difference in the way the court has perceived its role and in the way it has developed its jurisprudence. So we have to go back to the 2018 Polish rule of law crisis cases, whereby the court has clearly indicated that the principle of the irremovability of the judges is an essential guarantee of judicial independence. So you can see the cases that I have quoted here. So what does this mean? What does this essential guarantee include? It includes requirements that dismissals of members of that body should be determined by express legislative provisions, if available. So you have some cases for that. The second requirement is that this procedure must go beyond those provided by the general rules of administrative law and employment law, which apply in the event of an unlawful dismissal. So this is something else. Let's say we need a lex specialist. And judges may remain in post provided that they have not reached the obligatory retirement age by law, or until the expiry of their mandate, where that mandate is for a fixed term. So no early removal based on retirement. Of course, there are limitations to this. Not everything is a breach of essential guarantee of judicial independence. And this is where, of course, the courts, the national courts, are invited to exercise their discretion and exercise their balancing, their proportionality test to identify whether there is a risk to judicial independence or not. A judge may be unfit or incapacitated, or may be the subject of allegations of a serious breach of their obligations, of course. So how is this applied in practice? How is irremovability applied in practice? So it's not always easy to exercise that discretion, actually. So the court has also given guidance on that and said that in order to establish whether there is a risk to the principle of irremovability of judges and to the essential guarantees of judicial independence, then the court must be asked, or must ask itself, whether a judge's removal is warranted by legitimate and compelling grounds subject to the principle of proportionality. That is still quite difficult to do. The court has added a sort of a third element to the equation, in addition to legitimacy and compelling grounds and proportionality. The court has added a third criterion, by requiring that the measure is also not such as to raise reasonable doubt in the minds of individuals as to the imperviousness of the court concerned to external factors and its neutrality with respect to the interest before it. And this is where everything basically takes a different, different perspective potentially. I mean, no one can think that in a democratic society you would need to check this. The perception of individuals, the perception of justice, and whether there has been undue pressure by external factors. However, the court found it necessary to actually formulate it expressly and to restrict the exceptions to irremovability as much as possible. Of course, this is not flawless because the way the court has looked at irremovability, it's basically part of the judicial independence principle as opposed to using irremovability as a sort of a standalone principle which could be invoked before the courts. And as I said, it's difficult to imagine a situation in which the dismissal of a judge is done in pursuit of an illegitimate objective or disproportionately in a way that would not simultaneously give rise to reasonable doubt as to the body's imperviousness or neutrality. So the two go together. So in any event, it looks like a measure fitting any of those criteria would be a breach of an essential guarantee of judicial independence. But the reason why it's like this probably, it's because we have seen now new measures. We have seen that specific judges are being singled out, but we have also seen general measures or measures of general application being created. Okay, let's have a look at another one, which is important in today's context of austerity. It's commensurate remuneration, and that has created also some debate in Cyprus. Most member states have had that debate. So the receipt by the members of the judiciary of a level of remuneration commensurate with the importance of the functions they carry out constitutes a guarantee essential to judicial independence. That has been stated and stated again by the court. That requirement comes from, again, once more, the European/international legal framework of the Council of Europe. The idea is to protect the dependence of the judiciary from external interventions or pressure liable to impair the independent judgment of its members and to influence their decisions. So it does not necessarily prohibit the reduction of the remuneration of judges or of the judiciary more generally. We have had examples of this. An example of this is exactly the case that we started with, the Portuguese judge's case, whereby the gist of the matter was the remuneration, the reduction in their remuneration in times of austerity measures, and the Vindel case. The difference between the two is that Vindel was a single judge, whereas in the Portuguese case, it was the Association of Judges. But, there is a but, which is currently pending before the ECJ. We have a series of Hungarian cases that are based on something similar. And we're waiting to see how the court is going to treat them. I will develop this now. So, on the left side of the screen, you have the Portuguese case. On the right side of the screen, you have the Vindel case. Both of them in an economic crisis context. The reduction of judicial remuneration, or not only judicial, of civil service remuneration is a usual tool in economic crisis of austerity. So in the Portuguese case, in the ASJP case, the ECJ emphasized, first of all, several features of the measures before finding that they could not be perceived as being specifically adopted in respect of the members of the tribunal, but on the contrary, they were of a general nature and part of austerity effort. So in the eyes of the ECJ, that was in itself proportionate. The features that the ECJ looked at included the measures linked to efforts aimed at reducing Portugal's excessive budget deficit, in line with the economic criteria, the reduction according to the level of remuneration rather than sector of employment, and that measures were applied to civil servants more generally. And second, the court went on to highlight that the salary reduction measure was temporary in nature, thus suggesting that it was proportionate. There was no specific review of the importance of the judge's tasks needed at this point, because the measure was deemed potentially discriminatory but proportional. In Vindel, which was a preliminary reference on the legality of the application of very similar measures, but to a particular judge. First, the ECJ noted again the apparently legitimate objective and proportionality of the generally applicable austerity measures. But it went one step further because we were looking at a specific judge, and that specific judge had to establish why he was more affected than others, or affected at all. So it had to determine whether Mr. Vindel receives, following the salary reduction at issue in the main proceedings, a level of remuneration that is commensurate with the importance of the duties he performs. And this is the real question. And this is the one that was set in Cyprus, for example. And in there, the court felt that it didn't have the right tool to do that, so it actually referred the question back to the national court, because the socio-economic context of each member state is relevant here. So it seems that we have a two-step approach, if you want. First of all, the general approach for general measures, and then specific considerations of the commensuration of the remuneration to the task of the judge. And it's asking judges to examine this. So how can we reconcile the two? How can we reconcile judicial independence in times of austerity? This is a very crucial question. Well, as I said, it is a widespread tool to reduce salaries or deduct from salaries, or even pensions, for civil servants in particular, including the judiciary sometimes. So, as seen in Portugal and Spain, the underlying reasons for the reductions of judicial salaries are generally based on the arguments that there is a need for national solidarity in times of economic difficulty. And it's exactly what happened in Cyprus. There was a similar case before the Supreme Court in Cyprus. The president of the Supreme Court at that point was Justice Haji Hambis. And they ruled against the reduction of their salaries on the ground of judicial independence, which is enshrined in the constitution in Cyprus. However, they agreed to a voluntary reduction of their salaries to participate to the ongoing efforts towards meeting the austerity measures. So this is the solution that was found in Cyprus. And this is the solution, in fact, that was found in similar solutions that were found in many member states. As you can see from this list, there has been discussions about this in quite a few member states as far as the judiciary was concerned, and different solutions were found, let's say. It's worth noting, however, that in Cyprus there was no discussion to refer to the ECJ during this case. No discussion at all, and it was more or less the same time as the Portuguese case. So the approach was very different here. It was based exclusively on constitutional principles, and there was no debate as to whether the ECJ would have something to add. However, we can see that things are actually getting worse. For example, in the paper we have the references, of course, supporting what we are saying. In the Czech Republic, there's an ongoing discussion to permanently reduce judges' salaries. So that's another issue. So you will ask me, so where to draw the line? What is admissible, or what is permissible and what is not permissible? And it's actually sometimes difficult to draw the line between what is commensurate and what is incommensurate. And we come to the Hungarian case, which is currently pending before the ECJ. So this is the case of IS. So similar Hungarian measures will potentially be scrutinized in the IS case, in the IS referral, currently pending before the ECJ. And this set of measures is more likely to infringe the essential guarantee of commensurate remuneration, because there seems to be a real reduction of salaries. So a reduction of salaries in real terms, economic terms. Judges cannot afford what they used to afford before. Judges are threatened not to be at the same level as other public servants with similar qualifications, years of experience, and not duties, but level of duties. So there seems to be a real reduction of the salaries. The Advocate General in the case actually suggested, I will not even try to pronounce his name, Picamae, actually suggested that the question of remuneration is irrelevant to the main issue in the case, and therefore that question is inadmissible. However, let's wait and see what the ECJ is going to say, because we are in a different context. We are in a context of rule of law crisis, and we have as the background a possible illegitimate objective of dismantling the independence of the judiciary. However, given what we saw with the Portuguese case and the Vittel case, we are wondering whether maybe the way around would be rather legal actions brought by individual judges, like Mr. Windel did, which would need to happen at the national level, and there would need to be pressure for a referral to the ECJ, which again, in specific instances, may be very problematic for judges, or very dangerous for judges. Okay, a third essential guarantee, which to me is of much importance, I have to say, because I studied it quite a lot and I experienced it quite a lot as well, is the one of protection from external intervention or pressure. So, what do we mean by that? Well, we mean any external force that could potentially influence the judges and the judiciary in their mission. So that essential guarantee requires substantive rules, particularly as regards the composition of the body and the appointment, length of service, and grounds for abstention, rejection, and dismissal of its members, as quoted from the case law of the court. The court has referred to that freedom from external intervention or pressure as essential. So it's actually a freedom, which is very important. And how can external intervention be applied or be manifested? Appointments, terms of duration, remuneration seem to be relevant here. So we go back to the initial rule of law, Polish rule of law crisis cases, where in those two cases, ISC and JRA, the court found the new Polish measures governing the extension of term durations for the Supreme Court and ordinary courts problematic in light of the fact that the executive branch was granted discretion to provide for an extension of the period of judicial activity beyond the normal retirement age. And this goes on. The same issue of discretion was then seen with respect to new measures governing the appointments of judges to the disciplinary chamber of the Supreme Court in AK and others. So in that case, the court highlighted that the discretion of the president in appointing judges to the disciplinary chamber could be objectively circumscribed by the involvement of the National Council of the Judiciary, but the National Court to determine, it was for the National Court to determine whether that body itself was independent. But the CJ guided the court and suggested that, strongly suggested that it's not. So, measures considered can be found to be discretionary or arbitrary, where an executive's extension decision is not governed by any objective and very verifiable criteria, or the criteria are too vague and unverifiable, as the court puts out, or does not have to provide reasons, so there is no due process, in other words, or is not amenable to judicial review, so there's no way to appeal. So that seems to indicate arbitrariness. So, of course, external intervention cannot be avoided at all costs. We live in a modern world, modern democracy, where we have a balance of powers, and of course, powers sometimes not only struggle, but also meet with each other, especially at the EU level, I would say. You know, look at the way the EU functions, and you can see external interventions, not to mention external affairs and politics. So, what is acceptable and what is not acceptable in terms of external intervention? So, what sort of discretion is acceptable? So, the measures that grant the executive discretion, or sometimes we also call it executive dominance, without the presence of any additional independent body able to make such decisions more objectively, to make such extensions and appointments would be such as to exert an external influence of an indirect type, liable to have an effect on the decisions of the judges concerned. So the court has even recognized the possibility of the indirect influence. However, that has its limits, and the case of Republica, which is a recent case from Malta, shows this. I'm not sure I agree with that case, but anyway, in that case, Advocate General Hogan, and he was followed by the court, opined that Article 19, paragraph 1 of the TU and Article 47 of the Charter did not necessarily preclude constitutional court appointments by the Prime Minister, in the sense that objective criteria were apparently laid down in the Constitution, confirmed by the court. Okay, on the ground that this is enshrined in the Constitution, that should by itself give a sufficient level of essential guarantee of judicial independence. I would say that the test needs to go further than that, and it needs to actually look at how independent that judge is once appointed. The court covers this as well in the judgment of Republica. Republica is an NGO, by the way, so I put one of their pictures there. Republica is a Maltese-based NGO, Malta-based NGO, that was trying to basically highlight the level of corruption in Malta, and that corruption is potentially spreading to the judiciary through that process. We have something quite similar in Cyprus, by the way, to appoint judges. So, again, I go back to the Advocate General's Bobek opinion in the Procurata case, which is again a Polish case, which is pending before the court. where A.G. Bobek talks about the concept of judicial independence as a concept that actually has two aspects, an external aspect and an internal aspect. And he says the external aspect requires the court to be protected from external intervention and pressures, and he refers to Republica in particular. And the internal aspect is linked to impartiality, which again raises one more essential guarantee, the one of impartiality. He does, however, mention this phrase, which is, I think, extremely emblematic. Article 19, paragraph 1 of the treaty is simply an extraordinary remedy for extraordinary cases. And he even goes on to talk about pathology, pathological situations that need to be remedied a little bit like a hospital would deliver services to patients. And I quite like the analogy, I have to say. This is a good opinion to read. Okay, we are coming to the last part of the presentation of the lecture, which is on fundamental rules of judicial independence. So basically, it's the same consideration, but elevated beyond the essential guarantee of judicial independence. So after first asking whether public authority has failed to uphold an essential guarantee of judicial independence, if this is answered with a no, then it can be asked whether the relevant action under scrutiny nevertheless led to the breach of an existing fundamental rule integral to the establishment of functioning of the judiciary. So the notion of fundamental rules related to judicial independence originates in the case that I mentioned before of Simpson and AG, which was of relevance or which concerned the now defunct EU Civil Service Tribunal. So I'm not going to bore you with facts. You can find them on the slides. But basically, there was an irregularity in the appointment of the judges to the CST. And the question was whether that irregularity was of such of a nature that it would actually jeopardize the process. And the court stated that an irregularity committed during the appointment of judges within the judicial system concerned entails an infringement of Article 47 of the Charter, particularly when that irregularity is of such a kind and of such gravity as to create a real risk that other branches of the state, in particular the executive, could exercise undue discretion, undermining that integrity, the integrity of the outcome of the appointment process, and thus give rise to reasonable doubt in the minds of individuals as to the independence and the impartiality of the judge or judges concerned, which is the case when what is at issue are fundamental rules forming an integral part of the establishment and functioning of that judicial system. So this is where the test for the fundamental rules come from. I'm not going to develop it because we don't have time, but it's a very interesting test, especially taking into account the justice scoreboard and other surveys and barometers that shows that 1 in 4 EU citizens do not trust the courts in the European Union. There are variations per member states, but overall is 1 in 4. So what I did here, and is done in the paper in more details, is to apply those fundamental rules again to appointments, particularly appointments at the ECJ, looking at panel 255's role, national court appointments, and I cannot resist but discuss, of course, the fate of Advocate General, former Advocate General Laulhe Shaelou in the context of Brexit. We seem to have a case of removal, not of a judge, of an Advocate General. It's the same thing in terms of impartiality, independence, and duties, performance. it's the same value, the same importance. And Sharpson was removed from, potentially forcibly removed from her position due to Brexit. She tried to challenge the decision of the Council and of the representatives of the member states removing her. Basically, there is no decision removing her. There is a decision saying that, you know, from the point that the transitional period actually, it doesn't even say transitional period. It talks about the withdrawal agreement. And it says that all British nationals in the EU institutions must depart. That's what it says. She tried to challenge that. It's very interesting. Her argumentation is well put forward, of course. She's a very well-known barrister. She was a great advocate general all these years. And the judgments, so first of all, she challenged it before the General Court, and then she appealed to the ECJ, and this was done very, very quickly. Urgency procedure. And the judgments are a bit disappointing in the sense that they confirm the possible lack of judicial independence of the court itself, because basically they confirm the external intervention from member states and the Council in the appointment and potential removal of judges and advocate generals to the ECJ. So this is unfortunate. The appeal was ruled last week, and it doesn't bring much more to the table. As I said, her argumentation was much better than the answer, but okay. So the litigation now seems to be closed, and not in the best interest of justice, probably. Neither of the European Union, probably. So a few concluding remarks. Well, I don't really need to describe the importance of what we are discussing for democracy, especially in times of pandemic. First of all, the pandemic has created multiple situations whereby fundamental rights and freedoms have been restricted. So that's number one. And of course, judges are called on, or will be called on, to review those measures, but also the pandemic is likely to have not only long-lasting public health effect, but also economic effects. And there we are likely to see yet another resurgence of issues that we've discussed in the context of the financial crisis. So, all this, unfortunately, is very fertile ground for the development or the manifestation of a specific type of populism. And this is what we're going to do now, from now on, from this moment until tomorrow. We are going to look at how the judiciary can play a role in tackling populism. I have given you some tools to play with, and basically the questions for discussion during these 2 days proposed by Jacqueline could be the following. Why is the independence of national courts especially important in populist times? What might be the role of independent national courts to protect the rule of law and human rights during populist rule? What types of measures are especially pertinent to the establishment and functioning of courts and therefore judicial independence at this point? How does the EU principle of judicial independence apply to executive or legislative measures affecting the establishment or the functioning of the judiciary? I think that what we are going to talk about today will largely, today and tomorrow, will largely answer these questions. So, I am now done. Thank you very much. The working paper is not published yet. Neither have I put it on the Microsoft Teams because I still need to do a bit more proofreading, but it will be soon published, and it has an extensive list of resources and references that you can see from the case. from the presentation.